This was a tragedy first and foremost for Jacob Blake, who still suffers from grievous injuries. These are life-lasting injuries that he suffers from today. And then I don't want to leave out the officers whose entire careers, in fact their whole lives, have been judged by a few seconds that they conducted themselves on these shifts, and to their families, because there's a tragedy there. They've clearly been impacted in the several months that this decision has been awaited. And it is my decision now that I announce today before you that no Kenosha law enforcement officer in this case will be charged with any criminal offense based on the facts and the laws as I will describe them to you now. So it is our decision that no charge will be filed. I'm going to also tell you, just because I think it is important, that no charge will be filed against Jacob Blake in regards to this incident as well. For many of the same reasons, in terms of an overall discussion about this case, that is not something that the District Attorney's Office intends to pursue. Now, if the District Attorney's Office does not file charges, if that does not happen, then immediate transparency has to take place. And so what has to happen is, first, the DCI website will by 5 o'clock today have available their complete investigative file. And second, the District Attorney's Office, which is not only going to put this PowerPoint, which is an abbreviated version of our report, will be publicly available, but we have a more lengthy written report that will also be available to the public. Both of those things will be available on a website that will be identified in a final slide here, and they'll both be available at 5 o'clock today. In addition, Noble Ray, the independent use of force expert, has drafted a report with all of his findings. That also will be available at that time. The other thing I did, and I think this is an unprecedented thing in the state of Wisconsin. I don't think this has ever been done before. I asked the Wisconsin Attorney General to select for this particular case a use of force expert who I had nothing to do with hiring. So I asked them to find someone so that there would be a truly and completely independent expert on issues of police training and on issues of whether the use of force in this case was reasonable. And the way I did that was I asked them to select the person without me having any input. And what the Attorney General did was he asked Noble Ray, who's with me today, who accepted. And I knew Noble Ray's name. I knew him as a national and state spokesperson for police reform and talking about bias in policing, and a person who had spent, after a long career at the Madison Police Department, his second career was trying to be a voice on those issues on a national level. That is the legal status of the investigation. I now want to talk specifically about the law of self-defense. I do that because my laser focus throughout this presentation is going to be, if one was to charge any officer in this case, what would be the laws that govern that case? What would a jury trial look like? Because if you do not have a case you can prove beyond a reasonable doubt, as you're going to hear me talk about, then you're ethically obligated not to charge such a case. And in my belief is that this is not a case where there would be any dispute about any of the factual circumstances of this case except for one piece of the law, and that is self-defense. Remember, these are police officers who are uniformed officers. They're called to the scene on a designated domestic abuse call. When they get there, they know there is an arrest warrant for Jacob Blake, and they take actions at that time. And the question, really the only issue in this case, would be, do they have a right to the privilege of self-defense?